Not yet. Now it's beginning.
Okay. Distinguished guests, ladies and gentlemen, good morning, good afternoon, and good evening. I'm Li Dongpan. I'm pleased to welcome you all to the webinar on international protection of intellectual property rights. I'm the chair of IPBA IP Committee and director of TBR, an international committee of Guangdong Lawyers Association. I'm moderator of this webinar with my today's partner, Mr. O, sitting next to me. Dr. O and I will be moderator for today's webinar. The webinar topic is international protection of IPR. So as we all know, IP protection has increasingly become a global topic and important issue and concern for companies, international investment and trade. How to fully protect own IP rights against infringement and defend against bad faith IP legal actions. Our abuse of IP rights has become a significant test faced by every country and region. This webinar brings together panelists from the USA and China to share their experience and insights on IP protection. The webinar is hosted by IPBA IP Committee and co-hosted by the TBR and International Committee of Guangdong Lawyers Association. Before the session starts, I would like to introduce the panelists. Our panelists of the speakers are Judge Rondo Reader. He is the former Chief Judge of the U.S. Court of Appeals for the Federal Circuit. Hey, Judge Reader. I believe Judge Reader is online, so probably technically we could not see his face, but I believe all the on-site attendees hope to take a photo with you. So because of the online, we have to wait until next time. So our attendees can take a photo with you to show their partners or show their families. The other speakers, next one is Professor Da Song Yuan, a law school professor of Beijing Normal University. Professor Yuan, please say hello.
Hello.
Okay. Our next speaker will be Xiong Wen Yang, a law school professor of the South China University of Technology. Professor Xiong is sitting next to Dr. O, to my left. But sorry, in Guangdong is very heavy rainstorm. So I believe Professor Yang can come here right before his speech. The other speaker is Jack Shaw. He is an experienced U.S. attorney at U.S. law firm, Procopio Law Firm. We will introduce them a little bit more before their speech starts in the formal session. Today marks our session with distinguished guests. We have Mr. Jack Lee, the president of 30th IPBA, and the other beautiful lady, Ms. Xuan Zhou, the vice president of Guangdong Lawyers Association, sitting next to Professor Yang. They will give us opening remarks later. The co-organizer of the webinar are the TBR Committee of Guangzhou Lawyers Association and TBR Committee of Shenzhen Lawyers Association. So we have Mr. Xian, director of the TBR Committee of Guangzhou Lawyers Association, sitting on the other side next to Ms. Zhou. I'm the director of TBR Committee of Shenzhen Lawyers Association. I would also like to express my special thanks to the team who make this webinar happen. Firstly, a big thanks to Ms. Rhonda Landy, the Secretary General of IPBA, who has helped us with preparation in the last several weeks and continue to assist us in the whole session today. Hello, Rhonda.
Hi, everyone. Thank you. Thank you for joining.
Secondly, the Secretary Department of Guangdong Lawyers Association, Ms. Liang and Ms. Peng, who is on site right now. and also the Secretary Department of DBR and the International Committee of Guangdong Lawyers Association. Our Secretary General, Ms. Lu, sitting on the other side, and also my assistant Baby and Martin, they are also here. Now let us have the opening remarks. So a warm welcome to Jack Lee for the opening remark. I believe it's a beautiful video. Rhonda, please.
Okay, I will play the video with opening remarks from Jack Lee.
Distinguished Ms. Zara Machet, Program Coordinator of IPBA. Distinguished Mr. Pan Lidong, Chairman of Intellectual Property Committee of IPBA. Distinguished Ms. Zhou Xuan, Vice Chairman of Guangdong Lawyers Association. Distinguished speakers and moderators, ladies and gentlemen, good morning, good afternoon, good evening, depending where you are. Today, on June 9, 2022, we are gathering in the beautiful Greater Bay Area of China to focus on the important topic of international IP protection, share wisdom and exchange insights. Chair Lidong has been active in the circle of friends of the IPBA all year round, organizing IP forums, which is commendable. Lidong and I and other colleagues visited the Guangdong Lawyers Association in December 2020, and in December 2021, as the then IPBA president, I congratulated the 12th General Assembly of the Guangdong Lawyers Association, which is unforgettable. The COVID-19 pandemic, which has not been seen in a century, has brought unprecedented obstacles to human free exchanges and the mutual learning of the rule of law. However, during my 2 years presidency, with the strong support of organizations at all levels and the friendly help of everyone, our IPBA 30th Annual Meeting Conference, the Tianjin East Asia Forum, the Guangzhou Arbitration Day, the Forum on the Rule of Law in Capital Market, and other impressive webinars, all unprecedented, presented by way of on-site and online session, bringing a fresh Chinese style and leaving a Chinese imprint in the annals of history. First of all, as the 30th president of the IPBA, I would like to thank the Guangdong Lawyers Association, Shenzhen Bar Association, and the Guangzhou Lawyers Association for their sincere support to our association. Thank you to all the experts who care about the development of IPBA for your friendship. Without their strong support, IPBA could not have achieved such a meaningful transcript in the context of the raging global COVID-19 pandemic. This seminar focuses on the eternal theme of international IP protection. Senior expert lawyers from the Indo-Pacific region engaged in IP, judicial adjudication, and practical research will bring us an unexpected feast of the rule of law in IP. The IPBA will hold annual meeting conference in Dubai, Tokyo, and Chicago in 2023, 2024, and 2025, respectively. Here, we sincerely welcome all experts to register. The meeting and conference is short, and so is the life. However, the road of win-win and mutually beneficial development of IPBA is bright and broad, and it lasts from generation to generation. The long river of exchanges and mutual learning between human civilizations and the rule of law is endless and has a long history. Last but not least, I wish all the friends who attended today's seminar to be healthy and happy. I wish this seminar a complete success. Thank you all.
Thank you, Jack, for the excellent remark. Our next distinguished guest for giving the opening remark is Ms. Zhou, Vice President of Guangdong Lawyers Association. Ms. Zhou, please.
Thank you, Chairman. Thanks for the beautiful kind words. Respected President Zhiqiang Li, Chair Li Dongpan, dear guests, ladies and gentlemen, good morning, good afternoon, and good evening. My name is Zhou Xuan, the Vice President of Guangdong Lawyer Association. It gives me immense pleasure to welcome you all to the conference. It is great to see so many familiar faces today, together with some experts and lawyers across the world. I'd like to thank IPBA for its sustained support. IPBA is playing an active role in promoting the development of the Asia-Pacific region lawyers. It has attached great importance to the cooperation with international lawyers and bar associations. In the past few years, IPBA has organized some events in Guangdong province, say Guangzhou Arbitration Day, which is mentioned by President Li. It supported more and more lawyers to participate in international activities. We appreciate the opportunities. Guangdong Lawyer Association, as an organization with 42 years old, has more than 4,000 members and group members and more than 64,000 individual members, namely practicing lawyers. The aforesaid number ranks #1 in China. Yes, we are proud of this as well. Guangdong Lawyer Association always leads the advance of legal profession and serves the growth of the open economy in China and the world. We look forward to further cooperation between us. As you may know, in September 2021, our central government issued the Outline of Building and Intellectual Property Rights, IPR Powerhouse 2024 to 2035. Through a top-down design at state level. The outline will enhance the construction of international cooperation mechanisms for intellectual property rights. It also makes today's conference more meaningful. This morning, we will have sections and discussions on the topic of international protection of intellectual property rights. We are eager to hear from our speakers about their ideas and their views. This conference, we believe, will be a great platform for the attendees to share and learn. I wholeheartedly thank the organizing committee, the Intellectual Property Committee of IPBA, and the Belt and Road and International Committee of Guangdong Lawyer Association for giving such a wonderful platform to all of us. Thanks to the attendees. I sincerely hope you all will enjoy the conference today. 祝会议圆满成功. Thank you.
Thank you, Ms. Zhou. Next, we will proceed for this session. In the first place, I would like to introduce my partner today, the other moderator, Dr. O, sitting next to me. Dr. O will moderate the second half from the speech of Judge Reader. I will be moderate the first part. So let me introduce Dr. O a little bit. Dr. O is the former senior IP judge of Guangdong Higher Court. He has rich experience in IP law practice in China. In 1995, he started work for the Guangdong Higher Court. He was the vice president of IP division of Guangdong Higher Court and the vice president of Shantou Intermediate Court, being appointed by the Supreme Court of China. Dr. O has further studied at the University of London, the University of Washington, and the University of Madrid. He has a lot of international experience. He was named as one of the first IP experts in China and was elected as one of the first 12 experts in Guangdong. He has also served an adjunct professor at the National Lawyers College and Southwest University of Political Science and Law. He has also alumnus of the Southwest University of Political Science and Law. Dr. O, please say something about me.
I'm sure you may know Mr. Pan now, but you do not know more about him. So I introduce him. Mr. Pan is a managing partner of Reed's Law Firm, whereas an experienced attorney admitted in PRC in New York. He is the chair of the IPBA IT committee and a adjunct professor of Sun Yat-sen University Law School, adjunct professor of Guangdong University of Foreign Studies, an international law expert of Guangdong provincial government, a legal counsel of the Consulate of ROK, Singapore, Philippines, and a distinguished IP and dispute resolution lawyer issued by PRC Ministry of Justice. Already chairman of South China IP Arbitration Institute, annual judge of the Committee of Experts for Shenzhen Trademark Association. He is the director, advisor, and a member of the boards of various TDR and international law associations.
Thank you, Dr. O. Make me well known in the webinar. So for today's agenda, we will have 4 speakers with different insights. We will first have Jack Shaw share his insights on patent litigation in the Western District of Texas. Our second speaker will be Professor Yuan from the perspective of the Belt and Road Initiative to talk about the international legal service of IPRs. On the second half, we then will have Honorable Judge Reader to a speech on global IP protection. The last speaker will be Professor Yang, who will introduce IP protection in international trade and investment. After the speech, we will open for Q&A session. So let us get started with our first speaker, Jack Shaw. Let me introduce a little bit more about Jack Shaw. Jack is actually my alumni in Washington University in St. Louis. Jack is an experienced US attorney. He is a member of the IPBA IP committee. His service and specialization are the IP, litigation, corporate and commercial, consumer products, software, and Asia Pacific. Prior to practicing law, Jack worked as an engineer at a big high-tech company in Silicon Valley. Jack is a board member of the Asian Pacific American Bar Association of Silicon Valley. He is registered to practice before the US DTO and the US ITC, 2 very hard terms in China. He is admitted to the state of California, New York, Wisconsin, and Texas. Now let us have a warm welcome to Jack and his topic. Jack, the stage is open to you, please.
Thank you so much, Mr. Pan. Good morning, good evening, good afternoon, everyone. First, I really want to thank the IPBA and its IP committee for giving me this great opportunity to get to know everyone here and to actually share some of my experience with Judge Albright and the Western District of Texas litigation, Pan speaking. Also, I want to thank Mr. Lee, Ms. Zhou, and also Mr. O for moderating today's seminar. I really appreciate it. And I must say that I am even more honored that I have among me the speakers such as Judge Rader and also Professor Yuan and Professor Yan. And I feel pretty honored to be able to speak first. So hopefully I will do a good job. So you may see two screens here. As an engineer and lawyer, we are very conservative and very fail-safe people. So just in case one screen fails, I have another one. So we have double insurance here. So I will show my screen, my slides on one screen, and let me know you see you should be able to see my slides now, right? As Mr. Pan mentioned, I'm a lawyer at Procopio. I'm a partner at Procopio's Palo Alto office in California. And today I would like to, as I mentioned, I would like to share with you a topic which will hopefully be informative and helpful to you and your clients. Specifically, I'll be talking about Judge Albright's court and the practice before his court. Many of you may already know Judge Albright, his court has about 25% of all of the US patent cases annually, right? And he started only as a judge, I believe, at the end of 2018, sometime in 2019. So it's only been about 3-4 years, and he's already become very famous in terms of being a prominent patent judge in the US. And first, I'd like to explain why so many people go to Judge Albright's court. So you may have heard about this case called TC Heartland, right? Supreme Court case from 2017. This has shifted many of the cases from ED, Texas, which is right next door actually to Western Texas. It's actually not that far. From ED, Texas, such as Judge Gilstrap, Judge Schrader, Judge Mazant. Some of their cases were actually that would have been historically filed in their court could no longer be filed, under TC Heartland, and that's why there's a big shift actually just across the county line, right, or even the district line to the western part of Texas. Well, the Western District of Texas is actually one of the largest districts. It goes all the way to the western border of Texas, and also Southwest. So, and that's why. And then that's the first factor. The second factor is really because Austin, Texas is actually within the purview of Western District of Texas. And many of you may also know this. California is becoming too expensive. Many companies like Tesla, Google, Apple, they are all moving to Texas, right? And specifically Austin, right? So Austin is becoming a very important tech hub. And as a result, Western District of Texas, having Austin as one of its cities where many tech companies are located, is becoming an important venue for patent, because that cases filed in the Western District of Texas will have a very hard time to argue that they should be dismissed or transferred under TC Heartland, right? And also people like many plaintiffs like to file in Judge Albright's court is because of his 30 years of patent litigation experience, right? And he has very unique, sometimes very efficient rules and procedures. And the speed is very fast. It's about 17.5 months on average from the CMC to trial time, right? During the pandemic, that of course has changed, right? So that's some of the reasons why his court is becoming so popular in the US. So today I'll go over just a few, I think, some of the key information I'd like to share with you. And obviously each of these topics will warrant, by itself, a complete seminar on their own. So I like to go over something called the OGP, which is Judge Albright Standing Order Governing Procedure and Discovering Patent Cases. And then some notes about claim construction, AKA Markman hearing, trial, and some takeaways and tips that I myself have sort of experienced. I've been on both the plaintiff and the defendant side, and also what's happening with the judge. There's a new judge actually that got appointed recently. Judge Derek Gilliland. So let me start with the first topic. So this is, oh, as you can see on my slide here, this OGP was revised about 2 months ago, April 14th, 2022. And the reason partly is because Judge Gilliland was sworn in as a new magistrate judge to assist Judge Albright on April 1st, 2022. And the OGP, by the way, I will tend to show you on the screen as well. It's a very detailed procedure that we patent litigators follow, to the letter. It's very important. And the OGP also changes very frequently. I think it changes at least, in the past, at least probably 2 or 3 times a year, right? So the OGP just got changed. Judge Albright is trying very hard to have an efficient process. He's listening to different feedback from practitioners. So that's why the OGP also changes from time to time. And the OGP has, how you set the deadlines, right? So I said 17.5 approximately from the scheduling conference to trial. And there's a very detailed sort of suggested timeline that parties usually follow, right? Discovery disputes, very important for litigators and your clients who have done litigation. That's a big part of what lawyers and their clients do, right? There's a lot of discovery disputes, documents, information, right? Venue, right? People want to transfer, some parties want to transfer. And therefore, Judge Albright gives you a special procedure for venue discovery, right? And then there's meet and confer requirements. And then before parties enter a protective order, which is also very important for some of my clients, because we have highly confidential information, source code, financial documents that we are, and these are absolutely critical for our client to be to protect them from being disclosed to unauthorized parties, right? So that's why Judge Albright has something called the interim PO or protective order. And obviously claim construction, right? Very important, very critical. And then just some general issues. I wouldn't bore you with all the detailed deadlines, and because I'm going to actually show you on, in a nice table. But the first critical date is the CMC, right? This is the scheduling conference where the court will set a schedule. Then the Markman hearing is approximately 23 weeks after the CMC. This is where the judge or his appointed special master will hear Markman hearings, hear the arguments. And then usually fact discovery opens 1 business day after Markman hearing, right? And this is a good thing for some, I guess, defendants, because you don't need to worry about exchanging documents, rushing to your clients and start getting the documents because you don't really need to do much of that until the Markman hearing has taken place. And also 1 day after the Markman hearing, meaning 23 weeks plus 1 day afterwards, you have to serve your initial disclosures, which is not a heavy burden. So at least the defendant, which sometimes have more documents than the plaintiff, will have at least 23 weeks that they just need to focus on Markman, right? I think Judge Albright may think that Markmans can sometimes push for settlement, and that's one of the most important issues in a case, right? And another big deadline is close of fact discovery. It's 30 weeks. 30 weeks. So that's actually not many, a lot of time. It's 23 weeks minus, to 30 weeks. That's only about 7 weeks to do fact discovery. That's not a lot, right? So the nice thing about Judge Albright is he always, as long as both sides agree, he's gonna extend the schedule to a certain extent, based on reasons, right? But this is a very compressed deadline. So sometimes people just need to start gathering the documents even before they receive discovery requests, right? Because it's only it's only 7 weeks, right? Then you get 8 more weeks to do expert discovery, right? I mean, that's general deadlines, right? Most of the time, people try to negotiate and get slightly more time because this is very, very tight, right? You only get 8 weeks, 2 months to do your expert discovery, serving expert reports and conduct expert depositions, right? And then it's 40, And then the jury trial is usually set, about a year, 52 weeks after the markment. So if you do the math, that's, from 20, if you add all these weeks from the CMC, that's about 17.5 months to trial. That's pretty fast, faster than the national average for trial. And then I will show you, in the next document, there's very specific discovery limit, right? There's the limitation on the number of interrogatories you can serve, number of production requests that you can serve, and the number of deposition that you can conduct or defend. And just a quick note about motion to transfer. Judge Albright does give you a very specialized procedure and also a very a well-designed, I must say, deadline for people to move to transfer, right? Because if you want to move to transfer, you should do it earlier, right? Why moving to transfer 6 months after the case has been ongoing, right? So there's also a very stringent deadline on what you can do for transfer discovery and motion to transfer, right? And there's also the OGP document, which I will show you briefly afterwards, also has very specific page limit, right? Judge Albright gets 25% of the cases. It's a lot of cases. He probably has 4 law clerks now. It's still a lot of work for all the 4 law clerks, right? Judge Gilliland is a great relief, but still it's a lot of work. They don't want to read, thousands, hundreds of pages for every case, right? So and this saves, and this is good for, I guess, for practice, right? Less is better sometimes, right? So he has very stringent page limit. And I mentioned about the interim PO. And yeah, let me just go. I think we can talk about the markment a little bit before I switch to the next document. But yeah, there's the claim construction process and also the markment hearing, right? This is key, right? This is what you have to do early on in the case, right? And this is also from the OGP. It's very efficient. It's it's no waste of time or the resources for the clients. Even if you have sued someone with more than 5 patents, he sets the default limit to be 12 terms, meaning that no matter how many claims you assert, how many patents that you assert, the default is 12 terms, right? You can always request by emailing the judge's clerks by saying that why you need more terms, right? And you need to have pretty good reasons to do that, right? And this, so that's why there's a lot of strategy to think about early on, because markment is done first, claim construction process proceeding is done first. Litigants need to think about this very carefully as to what they want to do early on. What's the key term, right? What's their strategy, right, for both sides? And Judge Albright has a very, there's a technical advisor, and I think sometimes he's almost acting like a special master, Dr. Josh E. He's a very important person for those of us who actually litigate in Western District of Texas pretty often. He has a PhD because obviously he's a doctor. I think he has a PhD. He has a PhD in EE. So he's very well versed in EE software technologies, for example, right? And he was a former and he was a law clerk for Judge Albright for 2 years. He actually maxed out his term, and then he's now a technical advisor for Judge Albright, right? Josh E. not only would, and by the way, don't call him Dr. E, always call him Josh. If you call him Dr. E, he will be upset, so call him Josh. He's a very friendly guy. So Josh is not only the technical advisor for Judge Albright, he sometimes actually conducts the markment proceeding. He may even conduct markment hearing for some of the cases that are selected. So he's a very important person to get to know too. And then Judge Albright was at least very busy. Now maybe things are improving, but sometimes he could be conducting markment hearings over a weekend. So Judge Albright works very hard. Okay, so let me go to a document that I can share with you. And I think I have about 10 minutes left. I want to be cognizant of that. 10 minutes left, okay. All right, so let's see here. so this is sort of the guideline for those of us who litigate in Texas, Western District of Texas, right? This was filed on April 14th, right? So everyone needs to follow this. So I'm not going to go over the 18 pages, but Judge Albright gives you the address of the law clerks. You can always email them, very friendly. They try to resolve your issues very quickly. And I think he probably has 3 or 4 law clerks now, like I said. And now with Judge Gilliland on the bench, he may actually be handling some of the cases that your clients or you may be encountering. And Judge Gilliland, I do not know how many clerks that he has, but I imagine many people want to volunteer even for Judge Gilliland because it's such a popular court. So I'm sure they have some very good law clerks in Waco. By the way, so I don't think I explained the Waco versus Austin. Both Waco and Austin are within the Western District of Texas purview, meaning that companies that are within the Western District of Texas boundary lines can be sued in any of those courts. So when you file the case, you can file it in Waco Division or Austin Division, right? So even if a defendant headquarters are in Austin, the plaintiff can still sue that company in the Waco Division because it's still within the Western District of Texas. But sometimes some of the defendants would move for a intra-district transfer, meaning that they don't want to be in Waco, because if you're in Waco, that means that if and when you have a jury trial, you will be dealing with a Waco jury, which I don't think is that bad personally, right, compared to ED Texas, right? But still, people have some defendants may be more averse to a Waco jury than an Austin jury. So companies that have nothing to do Waco, they may actually file something called a intra-district transfer back to Austin, right? But plaintiffs still sue, wherever you're located in West Texas, they will still sue the defendant in Waco, because the reason for that is you will be guaranteed to get Judge Albright, right? If you file in Austin, then you may get Judge Deco, right? Or another judge, right? But if you file in Waco, because Waco, Judge Albright is the only district court judge, right? The other judges are magistrate judges who assist Judge Albright. If you file in Waco, whether you get transferred or not later on, plaintiffs still do that because you'll be guaranteed to have Judge Albright, right? Because for many plaintiffs, the whole point of doing this in Western Texas is to get Judge Albright and get his rules, right? So whether you could get transferred back, and another point is, whether you get transferred back to Austin or you are staying in Waco, you will still be under this OGP because that's Judge Albright's rules, right? So the plaintiffs will get the benefit of a quick schedule, a very structured schedule, right? So the notice of readiness is basically when the defendants have responded to the complaint, then this will trigger the CMC, as I mentioned, the case management conference, and then the CMC will trigger the rest of the deadline, which I'm going to show you very quickly. And I have the links in my slides that you can visit. This is from Judge Albright, the Western District of Texas Court website. So the deadline, so the motion to transfer the preliminary infringement contentions are all triggered off CMC, right? So CMC is the critical date, right? Everything is based off CMC, 7 days, 2 weeks, 7 weeks. I won't bore you with all the math and all the details to calculate. But so everything is based off the CMC, and after the CMC, everything will be based off the Markman hearing, right? So it's pretty logical, right? And then, like I said, trial is about 52 weeks after the jury selection. So I won't bore you with too much of the details because you can visit the website and get this PDF. So let me go back to my slides because I have about 6 minutes left. Let's see here. Okay, so trial. Okay, so if your clients or you have to go to trial, right? It's very important to get a good jury consultant. That's the key, right? Austin is very diverse, right? With many different ethnic groups, different people of different background, right? It's very diverse, right? Austin has always been the more progressive part of Texas, right? So it has a lot, and it has a lot of technical companies, right? So, the population, the demographic composition is very important, right? When we select the jury. So many of the defendants who are suing Waco definitely want to move back to Austin, right? Because they think the Austin jury pool is better, right? It's more educated, right? So more educated is usually, they're more reasoned. I mean, at least that's a perception. But Waco is actually, Waco actually has some tech companies too, right? SpaceX is there, right? Elon Musk company, right? SpaceX is there. L3Harris is, I think, it's a big defense contractor, and they make metal detectors for airport, right? So there are some high-tech companies in Waco as well. And there's a large military veteran presence as well, right? So, I think, and as I will show you, the verdict is kind of mixed so far, in my opinion. So you may have heard, I think you may have actually have heard of some of these cases, right? The VLSI saga, right? This is the first trial, and actually one of the local council friends is actually involved in that case, and I think their round 3 just got postponed due to COVID to November, right? So this is a blockbuster win, right, for this VLSI plaintiff company, right? Then the magnitude of scale drops a lot, right? Then you have the second, third, fourth, and fifth largest verdicts, right? So one thing I want to highlight here is, the fourth largest verdict is 14 million in favor of a Chinese company against another Chinese company. They are involved in LED war right now. Okay, so that's a very interesting case, but it's a pretty big exposure, right, for the losing side. Okay, so key takeaways and tips. Yeah, so people like Judge Albright's court also because cases before Judge Albright are not stayed pending IPR, because Judge Albright's rationale is you will go to trial in 17.5 months, right, which is about the same as any IPR, right? IPR, you need 6 months for the institution, 12 months for the final written decision, right? So why should I stay my cases when the IPR may not, because people don't file IPR on day one, they get sued, right? It takes several months to prepare the IPRs and do prior search. So his cases in theory will be over before any IPR is over, right? So he does not stay cases pending IPR, right? Much less ex parte re-examinations, right? We used to do that, right? We used to move state cases because we have filed ex parte re-exam, but no, chances is almost zero. I was able to stay a case last year, almost a year ago, but those were under different circumstances. And I think that case was stayed because there was some parallel litigation that would have impacted my client's defense position, and you had impacted the fundamental concept of standing, right? So if you have good reasons, Judge Albright will state the cases. But that case that I stayed for my client was not because we filed IPRs. Okay, winning MSJ, so motion for summary judgment, very hard. Damage theories, Judge Albright does not want plaintiff to come up with huge, large damages models because he thinks those are subject to review by Judge Rader's former court, right? So he don't want people to go too crazy about damage theory, right? So the VLSI is a huge win. So I don't know what the status is on appeal, but Judge Albright is not a big fan of large damages theories, right? Motion to strike, on the other hand, meaning that your expert came up with new theories, is fair game actually. Dauber motion is also a uphill battle because Judge Albright wants the evidence to come into trial. He doesn't want to exclude, evidence. Jury selection is a key. And at trial, Judge Albright strongly prefers direct answers, right? I think that's pretty much the same case for all judges, but he strongly prefers direct answers at trial. and the judge encourages efficiency, right? Only 15 hours per side. 15 hours per side, especially when you have more pan, more than one pan, will go like fast, right? So this is, you have to be very efficient at trial. And then in terms of PowerPoints, he doesn't like to have a lot of PowerPoints, for Markman, for other motion hearings, discovery hearing, he doesn't want to have too many slides. And then selecting a good local counsel is also key, because for local counsel who have done a lot of work before Judge Albright, it's very important. So here are the links that you can visit, or you can do a web search, right? You can just search Western District of Texas Standing Orders, and you will have this link here. And this is the OGP that we were looking at, but he has other orders, right? Motions to seal and the other good stuff. And then there's also a courtroom guidance. So this is for the jury trial. He's using the JERS electronic exhibit system. And there's some other PDFs that's important for trial. I think this is probably one of the last slides. Yeah, this is the last. This is the last slide. So Judge Albright is on the left, and this is Judge Gilliland being sworn in, right? So Judge Gilliland is interesting. He actually had cases right before he actually had cases, patent cases before Judge Albright, before he was selected for an 8-term magistrate judgeship. And he has a lot of good patent experience as well. And then Jeff Mansky has been there. Judge Jeff Mansky has been there forever. So he's also a very good judge. He will sometimes conduct your jury selection pre-trial procedures. Okay, that's all I have. Thanks so much, everyone.
Who have built the very good IP legal theory and practice in US. A very tricky question for you. Could you share some feelings or comments on the style of Judge Reader? Oh, it's a joke.
Yes.
Let's go to our next speaker, Professor Yuan. Let me introduce a little bit of Professor Yuan. Professor Yuan is currently a law school professor at Beijing Normal University. He has been teaching law since 2005 and practicing law since 1994. His research and practice area focus on banking, financing, and securities. Professor Yuan expressed us is that he has achieved many law degrees. He graduated from Sun Yat-sen University with law degrees of LLB, LLM, and PhD. He completed his postdoctoral fellow at Renmin University. He also received a US LLM degree from Tsinghua and Temple University. He says he's the distinguished visiting scholar of Macquarie University. Professor Yuan, it's your stage. Thank you.
Hello. Thank you, Li Dong. Hello, everyone. Good morning, good afternoon, and good evening, maybe, ladies and gentlemen. It's an honor for me to speak here. I rare, in fact, practicing patent law or trademark or any other IP law, but I do have 2 interesting cases about IP law that I ever met. About 20 years ago, the president of Pennsylvania University, Penn University, the president of this Penn University led the team to visit our university, the Beijing Normal University. It's a very big event at the time, because in the history of Beijing Normal University, maybe the first foreign or American university presidents visiting. But why the Penn University president asked one thing during the visiting to our university? If there was someone, ever graduate from this university have been running the Chinese Walden education company in China, Beijing. It's a very funny thing that Walden Business School is maybe the most famous business school in the United States. Always rank 1, right? Among the business schools. But the trademark in China and the business name in China of Walden was registered and owned by some Beijing Normal University alumni. That's very funny. Very funny. So that's a little disappointing for our university leaders, or they just for business, for the name, for the trademark of Walden. The problem was not settled down at the time at the meeting, and 10 years later they sued this Walden education company in Beijing. At the time, I was the legal counsel of Normal University, and they asked me, and this famous, maybe famous in Beijing, alumni of Normal University, the boss. It is a private company. It is irrelevant to our university. It just graduated from our university, okay? He asked me how to deal with the case. I just told him some points. Point 1, the Walden name is famous trademark, right? Famous business school, right? But 1 is famous trademark is in English, not in Chinese. So the Chinese trademark of Walden is not a famous trademark all over the world, even in China or America. And as you know, the trademark is first registered, first grade, right? And blah blah blah. And also, it's a very funny thing that that's about another case I ever handled about 30 years ago in Shenzhen, South China. The first case we can name it Walden versus Walden, American Walden versus Chinese Walden. Maybe because I'm also an LLM of the United States, I made them negotiate it and settle down, make agreement. So there's a happy ending. And also another case I ever handled was in Shenzhen about 30 years ago. The case is also very famous company, Walmart. as you know, there was the first Walmart supermarket running in China, in Shenzhen city. They found that some other enterprise registered the business name of Walmart, including one in the city of Zhongshan, my hometown. They registered a factory. It's called the Walmart Lighting Factory in Zhongshan City, also another city of the Philadelphia area, the Great Gulf area now. And the boss of this Zhongshan Walmart Lighting Factory found me and asked me to present this case. And another side is another very famous law firm in China. It's called the Jindu law firm. Both sides lawyer made deep and hard negotiation at the time. Also, two main points, maybe. One, the Walmart trademark is famous, very famous, but the Chinese trademark or business name in China, in Chinese, is not the world famous trademark in Chinese. And second, there was another trademark registered in Shunde City for the usage of electric facilities. That means another point that is not, this trademark in Chinese is not owned by the American Walmart. So we also negotiated and make another settlement. That's very two funny case I ever handled. Okay, let's go back to the lecture. One, foreign related legal tenants cultivate. This very important document issued by the Judicial Department of Chinese central government. Because all Chinese lawyers association, the lawyers profession are under the management and administration and service of this government bureau. Okay, so it's a guideline document, I think. Next please. Next please. Please turn the page. So under this guideline document from the Judicial Department of the central government, a lot of universities join the programs for foreign related legal tenants, cultivator, education, training, including our university. this nation, the whole China's legal tenants cultivate. I think that is running for years in degree education. Okay. Turn, please. And second, there are also another fields for international legal professionals. That's for the lawyers, such as our schoolmates, Li Dong Dong Pan Pan is our it's my roommate. He's my roommate during the undergraduate times in Sun Yat-sen University. In the Chinese history, the most famous handsome man is called Pan An. So Pan is the gorgeous man in Chinese, most gorgeous man in Chinese history. I think Li Dong Pan is also gorgeous in international legal professional service. It's called 领军人才. It's the specific projects in All China Lawyers Association. My name is Yuan. I always introduce my name to the international students in our China law LLM. Yuan means the same pronunciation, same spelling of Mandarin as money, the Chinese dollar. Okay, but I rarely have money because I am a teacher now. I rarely practice now, but I do have teaching and made some promotion for the international legal professions. Please turn. Next page. Next page, please. Yes, this one. About 5 years ago, I have been busy with the first time or researching projects from the All China's Lawyers Association. The name of the project was the Chinese Lawyers Strategy under the Belt and Road initiatives. I remember that our project team, including me, my doctoral students, Liu Huachun, now is some leader of the judicial department of central government, and also the magisterial student Zhang Zhiguo, now as the judge now. We make a hard work to do that project from the All China Lawyers Association, and the main conclusion or suggestion for the project was that we suggested that China should build lawyers another lawyers association across the border, across this country, mainly focus on the Belt and Road area. And this come true about 3 years later or 2 years ago. The central government approved to build this new lawyers association. It's called the Belt and Road Initiative Lawyers Association. Now it's running. That's my job. Okay, thanks. Have a good time. Hello, Lidong.
Okay, thank you, Professor Yuan. I believe that speech is important for the IP lawyer to do legal service for the IP internet protection. Most importantly, you're referring me, mentioning me a lot of times in the speech. Appreciate it. Now I saw Judge Reader already online. Judge Reader, hi. Actually, all the attendees wish they could take a photo with you, but unfortunately, you could not be here. So next time, I believe when the COVID-19 policy lifted, you have here, so we can take a photo with you, show our partner and family. The second half will be moderated by my today's partner, Dr. O. So Dr. O will introduce a little bit about Judge Reader. So please, Dr. O.
Judge Reader.
My dear friend, Dr. O.
Let me introduce Judge Reader. Judge Reader is a former Chief Judge of the United States Court of Appeals for the Federal Circuit. I just want to introduce him with 3 sentences. Judge Reader has been a thought leader in the field of intellectual property law and jurisprudence. His publications and his work teaching patent law globally to students, judges, and government officials. Secondly, Judge Reader is very famous. He is so famous that almost everyone in the IP field knows him or listen his teaching. Thirdly, Judge Reader is a very kind person. He is so kind that when you have any questions, he will help you and answer your question. Now let us warmly welcome Judge Reader and let's enjoy the happy time. Judge Reader, it's your turn.
Thank you very much, my dear friend, Dr. O. Judge O and I have been close friends for many years, and I have great respect for his many contributions to the law, and I have great respect for him as someone who continues to make those great contributions. I'm happy this evening to address a very important topic. I am sorry that I cannot be with you there in Guangzhou. I see you very closely now, Judge O. It's good to see you. I want to discuss a topic of great importance. But first, I hope that I will soon be able to return to visit with my many very good friends in China. I have continued to teach at Tsinghua University, but I have only been able to do that over the internet. And I look forward to once again being present for my students and to greet all of you as well. Now, tonight, this morning for you, excuse me, I would like to discuss the importance of international protection for intellectual property. I have taught intellectual property courses now for over 35 years. And I always tell my students, intellectual property is the one area of law which is international. I tell them, you cannot be a good intellectual property lawyer if you just protect property in your home country. You cannot just know the law of China or just know the law of Korea or just know the law of the United States. In order to really be a good intellectual property lawyer, you have to know the law and the practice across many different countries and jurisdictions. Now, let me tell you briefly what that means. That means first, when you initiate your intellectual property rights, when you file a patent or you register a trademark, it is not enough to do that just in your home country. You cannot protect your client and their intellectual property just by filing in China or just by filing in one other country. Now, let's be honest, it is very expensive to file multiple patent applications. And so you have to be wise as to which places you do file. My recommendation is that you file at a minimum in the 5 primary intellectual property countries: China, the US, Europe. I put that all together as one because it is possible to file at the European Patent Office and thus cover Europe as a whole, Korea, and Japan. I should also caution you that you would also perhaps wish to file independently in the United Kingdom, in England, because that has a separate court system and a separate jurisdiction because they no longer belong to the European Union. This, even if you just pick 3 of those 5s, it will be expensive, but it is important that you have rights that protect your intellectual property outside your own border. Now, the next thing of importance is a patent in particular is often just a license to sue or to pursue enforcement in a court proceeding. This means that in order to be a good intellectual property lawyer, you are going to need to cultivate contacts and have the ability to reach out to experts in each country that you filed. For instance, I know that if I am going to China to protect the important property rights of one of my clients, I will probably go first to Judge O. And I will talk with him about the proper process for pursuing enforcement of our property rights in China. I have similar contacts in Europe, in Japan, in Korea, in England, in the other jurisdictions that I've mentioned. Now, once again, we need to talk in practical terms. This can be very expensive to file multiple suits and have multiple attorneys. It can also be a great burden on your company. You need to send experts to China to testify, and then to Europe to testify. This can be a burden, but it is the way that you properly protect your rights, and that protection will bring vast benefits in terms of monetary returns if you pursue it with wisdom. Now, this will mean you need to know the advantages of each system. For instance, much manufacturing is done in China. If you can get an injunction banning the making or the export of a product, an infringing product from China, you have great leverage to enforce your property worldwide because you stopped the source of that infringement. Another example, the United States has a very expensive process called discovery. You're all probably familiar with this. It can be a great expensive burden, but it can also be an advantage. You can use discovery in the United States to learn precisely the activities that are infringing. You can get evidence that you can then use to certainly win your case in China, Korea, Japan, and Europe. So you can use the US system as a part of your international strategy to gather information. Finally, again, you might learn that in Europe, you can get a very early injunction often that once again gives you leverage for international work. I would mention one other point, and that is there is a way to avoid the vast expense of filing separate cases in each of the 5 jurisdictions I've mentioned. You could, with the agreement of the other party, have an arbitration, a single proceeding that allows you to resolve all your international issues in all of the countries in one proceeding. This also has the benefit of letting you choose the arbitrators, the judges who will make the decision. And arbitration is usually a very accommodating procedure. The arbitrators will be very anxious to give you full opportunity to make any argument you would like. Well, I've mentioned just a few of the important parts about an international strategy. I've focused mostly on patent law, but of course, the same applies to trademark law. You certainly need to protect your identifying mark in any jurisdiction where you're doing business. And once again, you need the contacts to enforce those rights if necessary. Let me just end my presentation in the same place I started, and that is intellectual property is the one area where you can't just practice your own nation's law. You need the ability to look internationally to protect the rights of your clients and their contributions to technology, their identifying marks, their trade secrets, their copyrighted material. All of these forms of protection must extend beyond the borders of your home country. Now, I thank you again for letting me speak to you on matters that I'm sure are quite familiar to all of you, but it's good to remind ourselves of the important responsibility we have to stay in touch with the law in many different places. I'd like to once again extend my greetings and my great thanks to many friends I see present, but especially Judge O. And with those closing remarks, I thank you for inviting me, and I hope that we soon meet in a place where we can take pictures, shake hands, and enjoy each other's company. Thank you very much.
Thank you, Judge Reader. I believe all your friends here and all your friends online, including Chinese and other countries, knows what you said and understand what you said. Just now you said IP law is international. It is part of TRIPS, I think. I don't know whether it's right or not. But the practice is different in different countries. So just now you tell us how to protect IP. There are 5 jurisdictions. We will keep learning. We will keep learning from you. You are the professor in Tsinghua University. Many Chinese judges are your students. I know them and they know you. I hope this time when you come to Tsinghua and come to Guangzhou and give us another speech. Thank you very much, David.
I look forward to seeing you again soon, my friends.
Thank you. Now, let's introduce Professor Yang Xiongwen. Professor Yang is very famous in China. He is not only a lawyer, professor, but he is also an engineer. In this field, in that field, a lot of professors just knows IP law, not IP. IP is patent trademark itself, but IP law is trademark patent. But Professor Yang knows IP and also IP law. Now, please warmly welcome Professor Yang to tell us how to protect IP, especially about improve the trade. Now, please.
Thanks you for your introduction. Distinguished experts attending the seminar, I'm a very pleasure to be invited to share my views on intellectual property protection in international trade and investment. As you know, the institutional questions of intellectual property protection has begun to occur and continue to intensify in the area up until global protection in the last 2 decades of the 20th century. In the post-TRIPS era, developed countries have restructured the rules of IP and international treaties through the multilateral trading system and international investment treaties, greatly reducing the policy and legal space of sovereign states. China and the United States formally signed the economic and trade agreement in January 2020, which constitutes the latest development in fifth-class standards. This international protection of IP promotes the development of international trade and investment, but also raise some new contents, even challenges. These 5 points listed on the slide are what I'm going to discuss. Part 1, challenges to existing rules of IP protection by the international trade and investment. The value of FDI, foreign direct investment, is becoming increasingly significant in international economic transactions. This trade-related investment matters agreement does not address the IP in foreign investment, nor does it require members to provide any other protection for foreign direct investment. Currently, these bilateral investment treaties are the main vehicles for countries to manage FDI. But many countries choose to incorporate relevant rules into free trade agreement, e.g. NAFTA Chapter 11, USMCA, and Chapter 14. In the recent series of TSO and PIPs, developed countries such as the United States have raised the international protection obligations related with intellectual property to the TRIPS Plus standard using their powerful economic skills and international discourse order. First, increasing the object of IP protection. Generally, the intellectual property can be protected by the investment treaty only if the investor has acquired or owned, which under the laws of the host countries and the type of which is covered by the investment treaty. Of course, if an IP application is protected by the laws of the host country and is given legal right, e.g. priority, the application itself may be considered property of the applicant under the laws of host country. Second, expanding the scope of IP protection. Third, extending the term of IP protection. Fourth, strengthen the measures of IP protection. Fifth, strengthen the counter restriction on IP restriction. Sixth, requiring contracting parties to undertake their obligations to join international trade on IP, involving all treaties under jurisdiction of WIPO, some regional treaties such as European Patent Convention, and the signing rule of which spans before and after the conclusion of TRIPS, etc. Up to the linkages between investment treaties and IP treaties. The linkages are mainly reflected in investment treatment clauses, such as non-discrimination provision, fair and equitable treatment, expropriation clause, umbrella clause, and prohibition of performance requirements. First, the connection between non-discrimination provisions and IP treaties. Since IP is an investment in investment treaties, non-discrimination provisions such as national treatment and most favored nation treatment in investment treaties shall be applied, which will lead to an overlap or even conflict between non-discrimination obligations on the investment treaties and on the IP treaties. Second, the complement to IP treaties by fair and equitable. Fair and equitable treatment is an absolute standard of protection. But most investment treaties do not specify it, making it one of the mitigation strategies for investors seeking investment arbitration, which challenges the host country's policies and or measures that are consistent with IP treaties. In practice, the invocation of fair and equitable treatment by IP owners is mainly reflected in the following two aspects. First, the violation of treaties by the host country automatically constitutes unfair and inequitable treatment for IP investors. Second, the host country's regulatory measures on IP are contrary to the IP owners' reasonable expectation, and therefore violate the host country's fair and equitable treatment. Third, banding of expropriation clauses and IP treaties. Under the expropriation clauses, host countries may not directly or indirectly expropriate the involved investment, unless conditions such as public due process, non-discrimination, and giving compensation are met. Most investment treaties provide that acts of revocation, restriction, and creation of IP. Consistent with treaties as well as compulsory lesson do not constitute expropriation. However, an investor may challenge the conformity of the host country's measures with treaties. It implies the existence of a possible expropriation unless the host country proves that its measures are consistent with treaties. Just as the judge read this evidence. Fourth, there are mistakes on the slide. Fourth, echo of umbrella clause. To IP treaties, umbrella clauses require parties to honor commitment made to offshore investors. Under umbrella clause, IP owners may also take IP treaties as commitment made by the host country and enforce it through the investment arbitration mechanism. Fifth, the transcendence of the prohibition of performance requirements in IP treaties. Under prohibition of performance requirements in investment treaties, host countries are not allowed to impose specific forms of performance requirements on the rights or treatment of foreign investors. Provisions such as prohibition host countries from imposing technology transfer requirements on foreign investment are TRIPS Plus, which expand the host country's intellectual property protection obligations. Part 3. Investor state dispute settlement, ISDS. Also, TRIPS includes the issue of intellectual property into the scope that can be lead to WTO dispute settlement mechanism. IP owners do not have right of action under the mechanism, but can only rely on their own governments to seek for international remedy. Bids in recent years have increasingly been used as a powerful tool for investors to challenge host countries' regulatory measures, including those related to IP. An investment tribunal may only decide on matters of investment damages and have no power to require the losing host country to modify or cancel its matters. Fourth, part 4. The applicable parts of TRIPS. Bids in recent years give investors fair and equitable treatment, but the contents are different. Bids do not contain IP rules. Their protection of IP is achieved primarily through linkage or combinating to IP treaties. In the application of international law, such as TRIPS, it can be broadly divided into the following categories. The first kind of bids, what is providing fair and equitable treatment, does not related to international law. Customary international law is separate, which gives the arbitral tribunal great freedom of interpretation. The second kind of bid uses international law as a frame of reference when interpreting fair and equitable treatment, and the discretion is of the arbitral tribunal is reduced. The third kind of bid links fair and equitable treatment to customary international law and defines it into the minimum treatment standard conforming to customary international law. Comparing the second kind of bid, the arbitral tribunal's discretion is more limited. The fourth kind of bids use open or closed enumeration methods to combine fair and equitable treatment with specific provisions or requirements, such as restricting fair and equitable treatment to no obvious discriminatory or arbitrary measures, and not truly refusing the fair trial. In this way, the broad and ambiguity of fair and equitable treatment is made up for to some extent. Part five, the impact of TRIPS plus intellectual property protection rules on China. Simply, the TRIPS plus is intellectual property rules in regional or offshore agreements has positive and negative impact on China. Chinese appearance acceptance of the TRIPS plus rules cannot be unlimited or current, and it must be tailored under China's national condition, and we must make specific judgment and favorable. Thanks. Really, all I want to say. Thank you.
Thank you, Professor Yang. The speaking session already closed, but we have. Okay, before we start the Q&A session, Dr. O will say something about the Professor Yang speech. Thank you.
Thank you, Professor Yang. After hearing his speech, I'm sure every friend may have some ideas. First, what is innovation? New technology, new product. Is it innovation? No. The creation is economic success. This is the first idea. Secondly, I love Professor's speech. What is investment and trade? Buy, sell, is it trade and investment? No. The economic success is trade. If you lose money, it's not trade. The thirdly, Professor Yang tells us the link between trade, investment, and IP. This is the core idea. I hope everyone knows this. Now let's formally thank Mr. and Professor Yang for us the secret of trade, investment, and IP. Let's make them successful. Thanks. Yeah. Okay.
So before we give the Q&A session, let's give another applause to all these speakers. On site and online, I saw Jack still there. Dr. Yuan still there. So thanks a lot for this time and your insights for the speech. But can I ask you to stay for another 50 minutes? Probably online we have some question. Our on-site attendees may have some question. Hello, Jack, you're still there?
Yeah, I'm here.
Okay, and Professor Yuan? So Professor always very busy. So let's start with Professor Yang and our Dr. O. You know, Dr. O is a former judge of Guangdong province. He is one of the most senior judges in China, one of the most famous IP experts in China. Let's make some questions, both to Jack, to Professor Yang, our Dr. O. Okay, if nobody has question, let me start a question to Jack. Not the question of your comments or feeling of Judge Reader, because he's not here, don't worry. But I ask another question. Can you share some of your experience when any international company, our foreign companies, have any IP litigation in US? I mean, if the claimant or if the defendant, what the normal our general strategy you will suggest, including the jurisdiction, including the procedure issue, our some a little bit tips on various of case.
Okay, so yeah, sure. Thank you, Li Dong, for the questions. Yeah, so venue and jurisdiction is always a problem, right? For foreign companies, Chinese companies, Japanese or Korean companies, right? It's always a problem. And also for, I don't know if there's any audience member from Taiwan. Taiwan is not a member of the Hague Convention for Service, which means that there are special issues that we have to address for our Taiwanese clients in those cases, right? But China, Korea, Japan are all members of the Hague Convention, right? So if someone only sues a Chinese company, Japanese company, or Korean company in Western District of Texas, Judge Albright, for example, and other judges, for them, for the fact is they will actually entertain motions to dismiss, right? Because if the service is not proper, right? If they only try to serve you through some Secretary of State in Texas, or they try to serve on your client's subsidiary in the US, right? Most of the times, there's some pretty good arguments that the service is improper. And I would force the plaintiff to go through the Hague, right? The Hague will take probably a pretty long time in China, Japan. I don't know about Korea. So that's a big jurisdiction and service problem, right? Jurisdiction is sometimes probably okay because Chinese companies do sell and their products do cause so-called infringement, right, in any district because the products flow through the interstate commerce. But for improper service, that's a big problem now. Many Chinese companies that I know are filing motions to dismiss. And other, I guess, tips for discovery is it's important to have good communication, right? I find that sometimes the client, defendant, a foreign company has very good case, right, from Taiwan or China or from Japan or Korea, but there's a huge communication problem, right? And there's a huge time difference problem, right? Sometimes the lawyers and the client in-house do not communicate well. And as a result, much information is lost in translation. So it's good to have basically teams that can actually talk to each other, in the local language or in English. That's very important, actually. I've seen this all over and over again. Clients come to us because we speak the language, and we work around the clock, right? So it's very important for, I think, Chinese companies, Korean, Japanese clients to deal with counsels who are, who can speak the language and who can actually understand their culture, right? And who can deal with their time zone difference, right? And, Californian lawyers like our, like my firm. So we actually have, folks who just deal with Asian clients, right? We basically change our schedule and we basically start working at this hour, right? To match with our Japanese, Korean and Chinese clients, and also our Taiwanese clients. So that's a few tips. Did I answer your question, Lidong?
Yes, very clear. Still there, Jack. I want to ask another question. I guess some of our attendees may have interest. If a case could be filed either to USA or to China, so let's say a patent case, a patent infringement case. It's happened both in China and the US. So from American lawyers' point of view, or from the Chinese judge's point of view, which jurisdiction will prefer? Chinese jurisdiction, our US jurisdiction. So let's start with Judge O. Dr. O. Just generally answer is okay. For example, if the claimant want to proceed the case very quickly, do you prefer the jurisdiction of US or you prefer the jurisdiction of China? If the claimant want the case closed very quick.
As soon as I know, the patent case, the litigation in China and the US is almost the same, difficult, and confused. Almost the same, difficult, and confused. First, in China, when there is a patent case, where to go? Where which court? It's confused in China. For trademark case, corporate case, patent case, in patent case, there is invention, unique model, and design. Where to go? Confused. Even there are 3 IP courts in China, Beijing, Shanghai, Guangdong, IP court. In our country, in our provinces, right? Even in Guangdong province, some invention and utility model cases go to Shenzhen, some go to Guangdong, IP court. Confused. I know. Confused. But in US, either. Such as Judge Reader, all the cases in the US under first instance, the second instance is handled there. But in China, the first instance case, I guess, we go to the Supreme Court. Now, some cases go back to High Court. This is confused. Also, there are things easy and, of course, different in 2 countries. So, in fact, in 2007, Judge Reader, me, and Judge Summer, we switched our court in US. The patent case, we made 3 judgments. Judge Reader made a judgment. I made a judgment. Judge Summer into justice made another judgment. The second, their own structure of law and the court, but we have some common things. This is my rough idea and see idea.
Okay, thank you, Judge O. Jack, if the claimant want to close the case as soon as possible, do you have any idea, any comparison of the speed of the judgment in Chinese jurisdiction or US jurisdiction?
So for speed in the US, right? I'll make sure. Okay, so yeah, so for the speed in the US, you go to Texas or the ITC, right? ITC is very quick, 9 months to trial, right? And this is a lot of pressure, right? It depends, and also it depends on who are you suing, right? And who are you defending against, right? So I'm in an ITC case right now, right? The case was filed in December and we are going to trial in September. So the speed is huge. It's a lot of burden on our clients, right? But for those clients who have the means to defend, ITC can still be very burdensome, right? So if you are the plaintiff or complainants, for speed, you go to the ITC, right? Assuming you have the right patents and domestic industry, right? But if you don't, then you go to Judge Albright's court, right? And that really depends on the business model, because there's also a lot of the e-commerce merchants. They actually flood the Northern District of Illinois in Chicago now, because there's some pretty favorable law for service against commercial, against e-commerce sellers, right? So that's actually becoming a big venue for online dispute, online related litigation, because the law in Northern, the laws and rules in Northern District of Illinois favor service by publication. So you don't need to go through the Hague anymore. The judges there have made the law such that you can be served with a website and followed by emails, right? Or vice versa, right? So and that's very fast, right? So For faster speed, again, Texas courts, most notably Eastern District of Texas, Western District of Texas, and the ITC, right? For the defendant, right? I don't know if that answers your question, but for defendant, I always have my client try to transfer back to my home court, right? Which is the Bay Area, right? San Francisco, San Jose, right? The Silicon Valley area, Northern District of California. That's the best court that's the best court for defendants in my humble opinion, right? It's slow, it's very slow, 4 years, 3 years to trial. And juries are more likely to find the patents to be invalid because many engineers in the valley, they view patents as a problem, right? They cannot innovate because of our patents. So there's a good segment of population who have aversion to patents, right? And also another good court, I guess, for Asian defendants is probably SDNY, right? Southern District of New York, right? It's also very diverse, right? So if I have a chance to tell my client who is getting sued, these are the two courts I would consider: Northern District of California, Southern District of New York, in my hand.
Okay, thank you, Jack. That's a good lawyer's answer, always depending on the case. We will try to give some cases here to try a strategy.
Yes.
Thank you, Jack. I guess the time run out, so our online session will be closed. We thank you again for all the attendees. Thank you, IPBA Secretary. Thank you again for the Guangdong Lawyers Association Secretary Department. So look forward to see you next time. Thank you, Rhonda, Professor Yuan, Jack.
Thank you.
Thank you,
Thanks so much.
everybody.
Have a good day. Thanks. Bye.
See you.
Thank
See you. Bye.
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 Thank you.
Okay.